Good morning, Judge Stevens.
Okay, we about ready?
Yes, it looks like we have counsel for plaintiff and the court reporter, and there's an individual in here who's not the primary attorney for the plaintiff, but I believe it's their co-counsel.
Okay. Well, I guess we'll find out.
Okay, I can bring them in when you're ready.
Thank you. This is case number 20-00040. Eugene Daneshvar versus the University of Michigan. Okay, counsel, if you would be kind enough to state your appearances for the record.
Good morning, Judge Stevens, and may it please this court. My name is Tarek Turfi, and I'm appearing on behalf of plaintiff Eugene Daneshvar.
Good morning, Your Honor. Brian Schwartz appearing on behalf of defendant, the University of Michigan.
Okay. We have our court reporter here, who is Ms. Rhonda Foster. More likely than not, Ms. Foster will be silent throughout this proceeding. However, if at any point in time she either loses connection with any of us or cannot hear or clearly understand what is being said by any one of us, she will make an amazing appearance and let us know, because she is responsible for maintaining the official record of these proceedings. This is a motion to compel discovery and for fees under MCR 2.3132 and 2.313A5. You have killed a lot of trees in furtherance of this motion, and I've had the opportunity to review the pleadings and papers. It appears to me that the principal issue is the extent to which any privilege applies, and more specifically, the extent to which the attorney-client privilege applies to the matters that are requested. To that end, counsel, I would really appreciate it if you would, and I know you have some other issues about the scope of FOIA generally, but understanding that the university did not prevail in its initial motion to dismiss this case because it is a relitigation of a previous matter. We're now at a different point, and I'd like it if you could principally focus on the issues of privilege and less in the minutia, that is to say, that requests to produce number 9,622 relates to X, but try to lump the things into categories, because that's how I've been trying to think. I've been trying to understand what, if anything, that is being requested is outside of privilege, period, regardless. What, if anything, is protected by the privilege based upon when the communication occurred, and what documents are outside of privilege, but which may, because of when they were created, but which may contain privileged materials inside. I will tell you why I'm doing this, in part because it is my intent to actually ask you to reduce that kind of conversation to a chart for me, and that it is my intent to afford you the opportunity to have retired Judge Ulysses Boykin wade through each and every one of these pieces of paper, as opposed to myself, and make some recommendations. I'm hoping that, for example, that the university, to the extent that there are documents which, based upon their timing, are probably outside the time that an attorney-client privilege took place, because there was no attorney-client relationship, but which include what you perceive to be privileged and confidential information. I'm hoping that what you'll be able to do is to provide retired Judge Boykin with both the original and your proposed redactions so that he's able to say, yep, we all agree it's outside the privilege because of this. Here are the redactions. Of the redactions, I recommend that we adopt all of them, some of them, none of them. So that you're using as little of his time, for which you will be paying, as possible. But it'll also give you a chance to move this litigation forward in a timely fashion. And with those preliminary, well, first of all, Mr. Turfey, did you understand what I was suggesting and why? You don't
Yes,
have to
Judge.
agree with it. I just want you to understand. I don't require agreement. Okay.
Definitely understand, Judge.
Okay, Mr. Schwartz, was I relatively clear?
Yes.
Okay. And with that, Mr. Turfey, if you would make whatever record you deem appropriate.
Judge, just to kind of piggyback off of your preliminary statements here, that's exactly what Mr. Daneshvar is looking for in this matter. Throughout this entire process, the University of Michigan has been using blanket privileges and blanket exemptions in order to deny document production, including this FOIA request. Mr. Daneshvar has never been afforded the opportunity to specifically pinpoint the privileges that are alleged to apply, the work product doctrine that's alleged to apply. These are usually and systematically, like I mentioned, blanket objections that the university is simply using to withhold production of documents. I think that if we can.
So, Mr. Turfey, just a question. I spent 28 years as a trial judge, and what I would normally get is a privilege log. I'd get a listing of requests to produce. In response to the request to produce, the defendant would routinely have assigned a Bates number to whatever the document was, and would in a chart say, this is in response to request to produce number 1. Here are the documents which we have in our possession, which we believe relate to this. Here is the date and time. Here is the sender, the receiver, whatever. And here is the privilege that is being asserted. Are you telling me you never got such a privilege log?
No, we received the privilege log, Judge, but
Okay.
the issue is exactly what you mentioned earlier. It's the timing, the application, and the overall scope, when you look at it from a narrow perspective of the exemptions and privileges claimed on these logs, and plaintiff needs to discover whether or not these apply on a line-by-line basis as they're used by defendant.
Okay, so I just need to drill a little down further.
Sure.
If you got a privilege log, and if the privilege log listed each and every document that they believed responded to a particular request to produce, did that privilege log also include the date of the communication, the sender and the receiver?
Not that I'm aware of, Judge, and I'd like to defer to Brother Counsel if he has that privilege log in front of him now. But nonetheless, notwithstanding the existence of the date sending and receiving, the application of for example, the attorney-client privilege, the attenuation thereof changes when the actual communication is used for the purpose of obtaining legal advice instead of being a mere carbon copy of an attorney on the communication. We believe and have great reason to believe that is
Okay,
exactly.
that's not, you're going to have to walk with me on this.
Sure.
If they tell you who the sender and the receiver are, and if they indicate and neither the sender nor the receiver are counsel, ordinarily, when I would get a privilege log, it would also say it went from X to Y with a carbon copy to Z, Z being the attorney.
Right.
So you got that, right?
Judge, I'd like to defer. I
Mr.
think
Schwartz?
Yeah.
Yes, sir.
Yeah, Your Honor, I figure it might be, I don't want to interrupt, but I
Not a
figure it sounds
problem.
like it might be a good opportunity here. We noted in our response brief, we did not provide a privilege log here. We noted we relied on, when the university responds to FOIA requests, FOIA doesn't require a privilege log. It requires the, generally
No,
describe.
And I know you didn't require a privilege log in the FOIA. That's not my
Yes.
question. I'm thinking because all of this stuff has been discussed in previous litigation, I was thinking that in the previous litigation, there may have been a privilege log. There was not?
That I was not involved in that. I do not believe there was. There were a total of like
Okay.
11,000 documents produced.
Okay. All right.
Here,
So let me make our life simpler then. How long would it take you? Because having this conversation without a privilege log is not terribly helpful. It'll tell me, we can have the discussion about, is this a fishing expedition, which, as you know, it has to be an expedition in the Atlantic when you're only seeking something from Chesapeake Bay for that to be able to be deemed appropriate at the beginning. So our conversations and our work would be more helpful if we had a privilege log. And I'm even willing to suggest that the two of you have a conversation about picking exemplar requests, because they're different kinds of requests. They're asking for billing data and stuff like that, and then they ask for communication. I'm thinking that if you did, for lack of anything else better, a trial, and you figured out 5. Mr. Turfy says, here are these 5 things I really need to know, and I really think are most salient, right? And you did a privilege log as to those. My suspicion is that if you do a privilege log, and if Judge Boykin goes through that privilege log and gives you some initial recommendations, that will help you guide the wise use of your client's resources as you go forward in managing the rest of this. Does that seem like, I know this is not supposed to be a pretrial conference, it's supposed to be a hearing on a motion, but
Yep.
whatever we can do to move justice along, we're going to try it, okay?
Your Honor, that makes sense to me. And I've actually found that these Zoom hearings have been actually more productive with discovery hearings for that very reason, is they seem to have sort of suggestions like that, which seem to make everyone's life easier.
Mr. Turkey, does that work for you?
that works, Judge. I think it's a good idea to get that privilege log so we can determine exactly what's going on.
Let's try this. And I'm not going to tell them to, you can make a decision on whether you want to do the full privilege log or if you want to pick your top 10 hits. Okay. And if I give you, today is the 15th, 16th. Well, I liked yesterday a lot. I wanted to relive it. Do you believe that you could both make a determination on whether you want to do the top 10 or the whole thing? I really recommend the top 10. And produce a privilege log in 2 weeks?
That should be, so that would be the 30th. That should be doable, I think, on the university side, Your Honor.
Okay.
I don't think there's a ton of documents that were withheld. There were a ton of pages, and I'm assuming that each, I haven't looked at them in a while. I don't think it's like, it was like about 200 pages. I don't think each one is like, okay, I have to do like 4 entries on that. That usually is what makes it lengthy. Some of these are, multi pages are all covered by a single line, which make it a more streamlined.
Okay. So here's what I would propose. I would propose that we adjourn the motion to compel to September 30th. I've just picked a random date. I'm hoping it's not a Sunday. But that in the interim, the parties will engage in the process of requesting and submitting a privilege log by August 30th. My judicial assistant will then set up a status conference via Zoom with counsel for the plaintiff, counsel for the defendant, myself, and Judge Boykin to determine the best process for getting a resolution so that I have a recommendation from him 10 days before the 30th. Does that seem like a good use of your time, Mr. Turfy?
Yes, it does. And just to clarify, Judge, 10 days before the 30th, meaning the later 30th of September for the hearing date?
Yes.
Okay, perfect.
So, Mr. Porter, that works for you. Ms. Lockhart will be in touch with you, the two of you, to find out a good time to coordinate that status conference with Judge Boykin after the 30th of August, meaning sometime in September. And we'll conduct that via Zoom. The theory is that the court will return to normal practice in September. My contention is that normal practice relative to status conferences is best served by Zoom, and making people trundle down to the courthouse is irrational and inappropriate, and that you'd all have to be all masked up and behind some plexiglass anyway. So we'll do that status conference by Zoom. Ms. Foster, we thank you for your presence, and we will request a transcript from you and get an order out by Friday.
Thank you.
Thank you
Judge.
very much, Mr. Turfy. Thank you very much, Mr. Schwartz.
Thank you, Judge.